You know, based on what you have heard, I hereby make an oral application that the two be released on reasonable cash bail and bond terms on the following grounds that I'll summarize my colleagues have put to you. You know, one, police cells are unsafe for the two. And therefore, it will be a risk venture for this court to remand the two in any police station. And because the law only recognizes two institutions for holding people in conflict with the law, that's prison and the police, they cannot be taken to a prison. Therefore, I lay the basis that you release them on bail. Two, Your Honor, this is an advocate, senior advocate, that has narrated an ordeal before court. I don't know where LSK is to deal up with this matter instead of dealing with the judicial officers to boycott going to appear before court. This is a serious issue that needs to be investigated by this court. A court officer also falls under the constitutional provision of the marginalized. Had you dealt with her and convicted her, the judicial sentencing policy guidelines recognizes age as a critical condition. She will not go for life imprisonment, or she will not go for more than 2 or 3 years. That is enough ground to release her. Fourth, Your Honor, the first respondent is a presidential candidate for 2027. She has declared an interest pursuant to Article 38 of the Constitution to stand for the position of the President of the Republic of Kenya. And this is a scheme from the ballot. The daughter, councillor, said she contested for the governor's seat of Machakos, grant her bail. The second respondent is a classmate of mine, and I'm conflicted. We went to school together, did law together, admitted together. He runs a law firm. He's an officer of this court. An attempt to incarcerate him, his clients will not have access to justice. You know, they might think he's on strike when he is incarcerated. Allow him to practice his law on the principle that he is innocent until proven guilty. The sixth issue, Your Honor, that comes into why you should grant bail is that the first respondent is a divorcee. the deceased took over as a wife. The constant is the former husband and now the current husband for the deceased. Must a divorcee still be pursued after 7 years? Courts pronounced and gave a divorce decree, nisi and absolute. If she had a plan to kill, she could have killed immediately. The divorce was present. She was. I'm sorry, the daughter tells me she was divorced 20 years ago. She can't be bitter. 20 years ago. The son was a toddler. It's not now they can decide to revenge after 20 years. You know, I bring also the 8th ground because of age, and I appeared before one of the courts around here, the famous case of Dr. Ubwak. May God rest his soul in eternal peace. We pleaded with Cliff Mbithe, with Shadrach, with the other advocates. But this old man is likely to die. And true to that, he's resting. This lady falls in that age category. If detained and such eventuality happens, the blame goes to the judiciary, not the state. Similar matter of Gakuo, the former county clerk of Nairobi City, pleaded age and health. He was incarcerated. He rested in peace. These are now the compelling reasons, Your Honor, that we have presented to you. To grant bail. The averments by the state as compelling reasons put on a scale of justice. You know, you'll get favor in our submissions. That application I've made to release the two on bail. What is the case law I'm relying on? The Court of Appeal decision of Caspar Oyamu, and whose witnesses in this matter were employees of the county government of Migori. He was released. What about us, mere mortals? The Court of Appeal released them and gave conditions. Your Honor, to contextualize concerning those in the dock, release them and grant very, very serious conditions. The state, I'm sure the state worked all over to get an authority from the Court of Appeal to counter what we have presented. They only got authorities from the High Court. And the principle is that the High Court's authority is superior unless they bring the Supreme Court authority. You know, these people are crying before you. These people are looking at you. The darling of the court is an accused person. Cliff tells me the favorite child of the court is a suspect or an accused person. And only their rights are constitutional rights, because they are blood that is red running in their veins. The state has no blood. The state has no feelings. And that's why the Constitution never gave the state any right at all. You want to kindly release these people who have been brought here to settle different scores. I rest my case. I leave it to Shadrach to follow.